officer Kim Potter has been wrongly charged with manslaughter in the death of Daunte Wright. I'm going to fight against that injustice. It's wrong. The manslaughter statute simply doesn't apply. It requires that the defendant consciously take chances of causing death. That's not what happened in this case. This is a case of the rule of the mob rather than the rule of law. The decision by Minnesota prosecutors to charge former police officer Kim Potter with manslaughter in the death of Daunte Wright is an abuse of justice. It's a shameful misuse of prosecutorial discretion, a violation of the rule of law, and a substitution of mob rule for criminal justice rule. It was a tragedy what happened. The police officer thought she was firing a non-lethal taser at somebody who had an arrest warrant out for him for armed robbery or attempted armed robbery. He was trying to escape, get behind the wheel of the car, which might have endangered the officers and other pedestrians. He might have been reaching for a gun. The decision to tase him was not an unreasonable decision. She then made a terrible mistake and pulled out the wrong weapon and shot him and killed him. It's a mistake. It's not a crime. Let me read you the statute that she was indicted under. The statute reads as follows. A person who causes the death of another, she did cause the death of another, by the following means is guilty of manslaughter. Okay. Number one, by the person's culpable negligence, whereby the person creates an unreasonable risk. Now, listen to these words. And, doesn't say or, it says, and consciously takes chances of causing death or great bodily harm to another. In other words, in order to convict somebody of manslaughter, you have to prove beyond a reasonable doubt that the defendant, whether it's a policeman or anybody else, consciously took a chance of causing death by culpable negligence. Now, there is no possible interpretation of the videotapes that we've seen, no possible interpretation that would lead to the conclusion that this police officer consciously took a chance of causing death. She had no conception that she was going to be causing death. Her idea was that she would be causing him to be tased, which is non-lethal, a young, healthy man. Tasers are used all the time. We liberals encourage the use of tasers rather than lethal guns. And she made a tragic mistake. She should be required to go into training and make sure that she understands the difference between a gun and a taser. All of that is perfectly reasonable, maybe suspended, conceivably even fired, although I don't think that would be justified in this case of a woman with more than 20 years of experience and a relatively clean record. But the idea of prosecuting her for a crime that she didn't commit is simply a function of mob rule. The mob wants her to be indicted. There are demonstrations all over the country, particularly demonstrations in and around the courtroom in which the trial is taking place today of Officer Chauvin. And mob rule prevails over the rule of law. You just cannot find a justification for charging this woman with manslaughter. You just can't make it up. You can't say what she did was so wrong that we have to find a crime to charge her with. That's Stalin. That's what Stalin and Lavrenti Beria, the head of the KGB, notorious KGB, did when Beria said to Stalin, show me the man and I'll find you the crime. That's what happened in this case. The mob said, we've shown you the woman. Now find the crime. If you can't find the crime, make it up. If you can't make it up, stretch the statute to cover the conduct. There is no constitutional way in which this statute could be applied to the conduct at issue in this case. Now, if the case does go to trial, and and if she is acquitted, that will probably cause more riots and more demonstrations and more violence because of raised expectations. You don't indict people when there is no realistic chance of a conviction. Now, will a jury convict? Jury can do anything. But I can't imagine any appellate court allowing a conviction to go forward on this record. Now, here's the theory that they probably will use, but it doesn't work. The theory is that she should not have tased him, that was wrong. It was a mistake to tase him. And if that was wrong, and if that showed unreasonable risk, culpable negligence, consciously taking chances of causing death, if the act of tasing fulfills the criteria of the statute, then they will argue that this is a legitimate case. But tasing is routine, and you're going to get 100 experts from all sides of the political spectrum saying when somebody with an arrest warrant is trying to escape. Now, what we don't know, what I don't know, maybe people know it, was the police officer aware that the arrest warrant was for attempted armed robbery, going into somebody's house with a gun, pointing the gun at the person's head, threatening to kill if you didn't get the money, and that he continued to own a gun thereafter. I don't know whether she was aware of that, but whether she was aware of that or not, she was aware that there was an outstanding warrant, and presumably what the subject of the outstanding warrant was, and the idea that she had to let him get into the car where he might have had a gun and might have killed the officers the way that New Mexico thug killed an honest police officer. I just contributed to his family's memorial fund because I felt so terrible about that policeman, so polite, being shot in cold blood. Policemen are shot many times a year, close to 50 times a year. Every year it varies. But the idea that a police officer has to let somebody go back in a car which might have had a gun and then drive away in a reckless manner, which could hurt pedestrians rather than tase them, is just wrong. And so I don't think you get to the point where you can say that she was culpably negligent in tasing him. If you don't get to that point, then the issue is if she was allowed to tase him, there's a simple principle of law. Mistake of fact is a defense to a criminal charge. If you mistake something, if you reasonably believe that you're using a taser, and she was yelling, taser, 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 then she shoots and she says, oh my God, I shot him. What could be clearer evidence that she did not consciously take a chance of causing death? So I don't know what's going to happen in this case. Irresponsible prosecutors have made the decision to make an irresponsible charge against a completely innocent person who did not commit any crime under Minnesota law. And they did it because the mob, the crowd, demanded justice for Daunte Wright. Well, justice for a victim doesn't mean injustice for the alleged perpetrator. There has to be justice for all sides. You know, the Bible commands justice, justice must thou pursue. In the Hebrew, tzedek, tzedek, tirdof. You chase after it, you run after justice. But it mentions justice twice, justice, justice. And the commentators interpret it as justice for the victim and justice for the accused. You need justice for both. You can't just have vigilante injustice. And that's what we're seeing in this case. This is vigilante crowd mob injustice, making up a crime that doesn't exist and charging this woman with something she didn't do. You just cannot claim reasonably that she consciously took a chance of causing death when she believed that she was firing a taser. So let's see where this goes. It's not going to result in a conviction. If the jury convicts, that's always possible. The Court of Appeals will reverse. If the Court of Appeals doesn't reverse, this case will go to the United States Supreme Court because there is a constitutional prohibition against ex post facto application of the law or against bill of attainders. You cannot just apply an inapplicable statute. The Constitution requires fair warning. Thomas Jefferson once said, a criminal law has to be so clear that you can understand it while running. That's an interesting metaphorical phrase. While running, you have to understand it. I don't understand this statute while sitting to apply to the conduct at issue in this case. I have to tell you, I used to teach these cases all the time, and I would give law school exams. If I gave a hypothetical based on this case, and a student said that the manslaughter statute applied, even with great inflation, I can't imagine giving higher than a D minus. And I would call the student in and say, you sure you're in the right profession? How can you possibly apply this statute, which talks about consciously taking chances of causing death, to somebody who the videotape shows clearly did not make a conscious choice to shoot a gun? She made a conscious choice to shoot a taser. A taser did not culpably, negligently, unreasonably create a conscious risk of causing death. So, yeah, you flunked the exam. I'll give you a D minus because nobody flunks anymore with great inflation, but that's the functional equivalent of a D minus. So I give a flunking grade to the prosecutors who brought this manslaughter prosecution. And I'm not going to let this rest. I'm going to stay on this. And if the defense wants my help in this case, you can have it. I will consult with you. I will confer with you. I see a massive injustice occurring in this case, and I see a massive injustice being risked all over the country when you have mob justice replacing the rule of law. The rule of law requires that you take this statute and you read it and you apply it, and you apply it fairly and justly, and you don't listen to the crowds demanding justice, justice, justice. You do justice. You do justice according to the law, not according to the mob. So I want to hear from you. I want to hear whether you think this is just or whether you think this is mob rule. And I want to know what you think we should do. I'm offering my assistance here. I'm offering my aid. I'm not going to take a fee for it, obviously. I'm not engaged in unlawful barratry. As a civil libertarian, I am saying this is an injustice, and I fight injustice wherever I see it. I fight it when the police are wrong. I fight it when the police are right. I'm on the side of the victims when the victims deserve to have prosecutions brought against their victimizers, and I'm on the side of the defendant when I think the defendant is being wrongly charged. I am on the side of the defendant in this case. She is being wrongly charged, falsely charged, illegally charged, unconstitutionally charged, and unconscionably charged. And we have to put an end to this kind of mob rule, and we have to put an end to this kind of injustice by crowds. We have to apply the law no matter what tragedy occurred, no matter how wrong it may have been for this young man to die at the hands of a police. Accidents happen. People get run over. Bricks fall off buildings. People are killed as the result of accidents, as the result of mistakes. There's a big difference between a mistake and a crime. This woman committed a mistake and not a crime. Let's hear your views on The Dershow. Now for my favorite part of The Dershow, the wits, your comments. First call.
Hello, Mr. Dershowitz. This is David calling from Holden, Maine. Professor, my question for you is, if Derek Chauvin is convicted of any of the charges that are pending against him right now, could this set a precedent in the future for cases that, say, an officer deploys a taser and this causes the death of a suspect due to unknown underlying medical conditions? Could these possibly result in charges? Thanks for the question.
Well, it's a great call, and it relates both the Chauvin case to the more recent Potter case, where she thought she was firing a taser and she's been charged with manslaughter. No, I think if you use a taser and you use it reasonably and someone dies as the result, that's not a crime. But, you know, we live in a world now where what used to be the law is no longer the law. And the mob seems to be determining, rather than the statute books, what a person should be charged with. We're moving away from the rule of law and due process. And I think charging Chauvin with a second-degree murder is an example of that, and charging Potter with manslaughter is an example of that. And we have to demand a return to the rule of law.
Hey, Alan. This is S.G. Black, Washington, D.C. Topic that I'd like to bring up is that if the Capitol police officer who killed Ashley Babbitt acted out of, quote, fear, mistake, panic, misperception, negligence, or even poor judgment, end quote, the Justice Department says the act, I quote, did not meet the threshold required by federal law to pursue criminal charges, end quote. Why is this standard not being applied for Officer Kim Potter? Thank you.
You make a good point. I think the same standards have to be applied across the board. And what we're seeing in the Kim Potter case is selective injustice, mob rule. We're seeing a complete ignoring of the words of the statute and of the constitutional requirement that criminal statutes, be clear. And so I agree with you. I think we're seeing a double standard applied.
Hi, Alan. I just wanted to hear your thoughts on the new video from Project Veritas that came out regarding CNN and making up false stories, or stories that have no base, in fact, rather, to be more precise. I don't know if you mentioned it already in the podcast. Just interested to hear what you have to say. Thank you.
Project Veritas has simply confirmed what I think any reasonable person already knows, certainly what I know, that CNN has no concern for the truth and for adequate and accurate reporting. They have an agenda. Their agenda was to see that President Trump was removed from office, and they would do anything to do that. Their agenda today is to make sure the Democrats prevail and the Republicans don't. As you know, I have my own experience. I said on the floor of the Senate that a president could be impeached if he did anything that was unlawful or illegal. And then I went on to say, but if he just engaged in a quid pro quo that he thought was in the national interest by helping him get elected, that would not be impeachable if it were not unlawful or illegal. And the CNN just doctored my tape, took out the sentence about unlawful and illegal, and then had their commentators go on and say Dershowitz says a president can do things that are unlawful or illegal. They totally just doctored the tape to make me say the exact opposite of what I said. And so, of course, I'm suing them. And the Veritas issue will probably be of relevant fact to be introduced in the trial. But I think any objective viewer now understands that you don't go to CNN to get an objective assessment of the news. They are a propaganda outlet, not a news platform. And it should be obvious to any viewer, but they hide it. They have some good people, but many of the people just follow Zucker, who is the head of the company and who is an ideologue and who manipulates facts and just does things that no reputable journalist would ever do.
Hi, great show, Professor Dershowitz. This is Dorothy from Orlando. My question is about the Chief Justice of the Supreme Court. Does that person in that position have any ability to influence the leftward or the rightward tilt of the court? The Speaker of the House and of the Senate certainly controls what sort of legislation gets addressed in Congress and when votes occur. So my question is, does a Chief Justice have any similar political pull in how the court handles its business? Thanks. I'm looking forward to your answer.
It's a great question, and the answer is subtle. The Chief Justice does have somewhat greater influence than associate justices, but nothing like the majority leader of the Senate or the Speaker of the House. The Chief Justice doesn't control the agenda of the court. There are 9 justices. They meet, when I was a law clerk, they met every Friday in conference, secret conferences. I'll never forget, I had to break into the conference one Friday morning to tell the justices that the President of the United States, John Kennedy, had just been shot. And a number of the justices then came to my office because I'm a baseball fan, and I had a television in my office because the World Series had just been a month and a half earlier. And so a number of the justices were in my little cubicle watching as the news got worse and worse about President Kennedy. But they meet in secret session. Nobody's allowed in. I had to knock on the door and be allowed in just to give them the terrible, terrible news. The Chief Justice does get to, if he is in the majority, get to assign who writes the opinion. But if he's not in the majority, the senior person in the majority gets to write the opinion. He also gets to speak last at the conference if he chooses to. And he has some degree of control over the timing of arguments, but nothing near what the comparable heads of the Senate and House have. So the Chief Justice is really one among 9 with a little bit more influence and certainly a little bit more symbolic influence. He is, by the way, not the Chief Justice of the Supreme Court. He is the Chief Justice of the United States. That is, he is the head of the judicial branch of the United States. He is the presiding official, not only of the Supreme Court, but of all the courts in the entire country, all of the federal courts in the country. That's why they're called the Chief Justice of the United States, not just the Chief Justice of the Supreme Court.
Hello, Professor Dershowitz. My name is Elliot from Brookline, and my question to you is regarding vaccinations. Can employers compel their employees to be vaccinated? Can that be made a condition of employment? Some of the stuff I've read online says yes, some says no, so it seems like it's a gray area, and I would love to hear your informed opinion. Thank you, and I love the show.
Thank you. I don't think it's a gray area. I think employers generally do have the right to compel vaccination as a condition of employment to protect their other employees. I think universities have the right to compel vaccination as a condition of teaching or being a student at a university. The exceptions come up when you have people who have a physical disability, and the Americans with Disabilities Act may cover that, or people who have a religious objection. I've never understood the religious objection. Every religion seems to want to favor life. I know my religion says choose life and requires you to take medical care of yourself to protect yourself and your children and your family. But if you do have a valid religious objection or a medical objection, you may be able to qualify for an exemption. But in general, if you just refuse to take the vaccine, an employer can say, look, I don't want to endanger my other employees, and so you can't come to work, and I am not obliged to allow you to work at home. So if you want to work for my company, you have to be vaccinated. I am fairly confident the courts would uphold that. Certainly would uphold it by private companies. I think they would uphold it for public employment as well. Well, thank you all for listening and viewing and for subscribing. I hope more of you will subscribe. Because we don't have as many viewers and listeners as I'd like to have, we have a lot, but we need to have more to sustain a once a day show. We may have to move to fewer times per week, and we may have to move from video to audio. We'll be talking about that in days to come. In the meantime, continue to watch and listen to the Dershow, and most of all, please continue to call in and give me your commentary and your questions. As I've said, that's the favorite part for me of the Dershow. An important part of the Dershow is your voice, your questions, your comments. Please call 24/7. The number is 216-710-0050. Keep your comments short and to the point. Again, the number for you to call 24/7 is 216-710-0050. Hard questions, criticisms, everything's fine. Just keep your questions short, and I'll answer them all on the Dershow.